SJC-12021, Shrine of Our Lady of La Salette v. Board of Assessors of Attleboro.
Good morning, Mr. Tillotson. Ms. Tillotson, in the words of Yogi Berra, it's deja vu all over again.
Yes, Your Honor. Good morning.
Thank you.
May I begin?
You may.
Good morning. May it please the Court, Diane Tillotson and Ryan McManus for appellant, the Shrine of Our Lady of La Salette. This morning, I want to suggest a framework for applying the Clause 11th exemption that both honors this court and this Commonwealth and the statute's broad interpretation of the religious worship within the Commonwealth and the role of charitable works within that worship, while at the same time being consistent with the language of the statute itself and the cases that this court has decided. I would suggest an analysis that asks three questions. First, is the property in question owned by a religious organization, and is the dominant use of that property for religious worship and instruction?
Where do you get the dominant use test from?
That is right out of the Framingham case, Your Honor, where this court specifically determined that ancillary uses, and Framingham is particularly instructive because that case involved two separate buildings. Here we have a number of buildings where one building was used exclusively for the classic worship tradition, and the second building was used as a vestry. It hosted card parties, bingo, and in that case, the court specifically referred to dominant purpose.
Didn't they do that as it related to Clause 3rd?
No, not the Framingham case, Your Honor. The Framingham case was specifically a Clause 11th exemption case.
But when they used that language and they were going back to Steed, they weren't referring to Clause 3rd?
They may have been referring to case law interpreting Clause 3rd in that case, Your Honor, but it's clear that they pulled and applied the dominant purpose test under Clause 11th. If I may continue, for those purposes that cannot be considered strictly religious worship or instruction, the second question I would consider for this court's application is whether or not those other uses of the property either support the religious worship or instruction, or they're connected with that religious worship or instruction. And in this category would fall things like a maintenance shed, a cafeteria, a kitchen, a bistro, all of those types of uses.
What if a church had a gym and they rented it out to private organizations for basketball?
I think, Your Honor, the cases, I would suggest that both the statute and the cases read together would not allow that use to be entitled to an exemption. The court, you didn't specify whether or not the gym in question was a for-profit or a not-for-profit gym, but I would suggest that going back as far as 1840 to the Lowell case, it's pretty clear that one bright line test that this court has applied in the past is that use for a profit organization. In that case, it was a rental to a group of stores where the only connection with the church was that the funds, the proceeds from the rental, was used to support the church, that was not a sufficient nexus for purposes of entitlement to the Clause 11th exemption. I would suggest that if there is, and this goes into the third level of inquiry where the issue is whether or not there's an appropriation to a use, I would suggest that if a use or if another organization is renting on more than an occasional basis, that the inquiry should be, is that use, is that other organization intrinsically connected to the worship and the mission of the religious institution in question. And I would suggest in this case, the safe house is intrinsically connected to the mission of hospitality and shelter for pilgrims and those in need
So you
of the
would
La
say-
Salette
you would
Fathers.
say if a church has a basketball court and it's primarily used for the CYO team, but it rents out occasionally to a rec team, then there'd be no problem.
If it's used only occasionally by a CYO, absolutely. I think that's covered by the exemption, and I think that language is the occasional or incidental use that's specifically mentioned in the statute, Your Honor.
But that would only be for nonprofit organizations.
That is correct, Your Honor.
And wouldn't they qualify themselves? Wouldn't there be a qualification for under Clause 3rd for those organizations?
Possibly, Your Honor. They possibly could come in under Clause 3rd, but for a church to make a determination on a very temporary basis that they were going to allow a for-profit use come in and have to, strike that. Actually, a for-profit organization could not qualify under
Right.
Clause 3rd.
But
Sorry.
a nonprofit could.
A nonprofit absolutely
So
could.
there'd be two ways to do the same thing, in other words, as to, for example, the use by the shelter.
There would, Your Honor. I would suggest, however, a couple of practical as well as more principled reasons why using the Clause 3rd Form 3ABC does not work in this case, does not work for churches. The first is, from a very practical perspective, the Shrine of Our Lady of La Salette actually filed under Clause 3rd in a subsequent tax year, and I believe I apprised the court of that in Rule 16L letter following the last argument. Secondly, in this case, in this very case, the only issue involving or potentially involving Clause 3rd is that safe house, which is a very small portion. It's one building on a 300-acre property. Finally, if you look at the forms and what it asks under Form 3ABC, it's like trying to fit a square peg into a round hole. The Form 3ABC requires business income, business revenue. It is not geared to being filled out by a religious organization. Moreover, it would require a religious organization to parse through its activities to make a determination what is charitable and what is religious, because for so many religious denominations in our Commonwealth, charity is so intrinsically a part of that religious organization's theology and approach to its mission that it's really unheard of for the religious organization to say, oh, this is my charitable piece and this is really religious worship. It's just not separate.
So is your view that every Catholic hospital is within this exemption?
No, Your Honor. I think that, first of all, I think that it has to be part of the mission of the organization.
Okay,
and I'm
well,
not
I mean,
sure.
one would say that healing is part of the mission. I mean, there are Catholic hospitals, so I presume one could argue it's within the overall mission of the Catholic Church.
And secondly, I think it has to be connected with the house of religious worship. I'd suggest in this case the entire campus is a house of religious worship. I'd also suggest that a hospital could never be considered incidental. And I'm looking at the language of the statute that says occasional and incidental use by 501c3 organizations or not-for-profit organizations is not considered an appropriation. I think if you were running a hospital, given the level of regulatory constraint on hospitals, I don't think that that would qualify both as part of the mission and as incidental to the house of religious worship. I also think it's a very fact-driven inquiry. For example, if during the Civil War, for example, if a church gave aid and ran a small hospital for wounded soldiers, that may have been part of the mission. But I think the kind of hospital that we're talking about now probably would not fit within the religious exemption or the intent and language of the statute.
Using that phrase, campus, what about the carnival, the for-profit carnival? How does that fit in to religious worship?
I think the carnival has to be viewed as actually an activity of the church itself. It is run by an outside, and I will grant you, profit organization, but it is a fundraising activity of the church. It is truly incidental. It takes place on 2 days of the year as compared with masses, confessions, rosaries that take place 365 days of the year. And that carnival is brought in order to support, specifically to support the work of the La Salette mission. It's not, there is no giving over of the property, no transfer of the bundle of sticks, if you're looking at it from a real estate lawyer's perspective, to that carnival. They come in, they're totally controlled by the shrine. A portion of the proceeds goes to support the shrine, and it is looked at as an activity that's sponsored by the shrine.
Now, you mentioned the third question, and I think you made some allusion to it, but I don't know that you precisely articulated the third question.
Yes, the third question would be, is any portion of the property apportioned for or appropriated to a use other than for religious purposes or instructions? And again, keeping in mind that that use by a non-for-profit for on an incidental or occasional basis has been deemed specifically by the statute not to be an appropriation. And I think the word appropriation is significant because the statute uses the term house of religious worship. It does not talk about only that portion of the house where religious worship is conducted. And as we all know, houses have many rooms. They have furnace rooms, they have kitchens, they have rooms where people congregate and eat and sleep. I think so long as there's nothing that's appropriated and totally outside, taken away from the use for religious purposes, that the exemption applies to the entire house.
May I ask you, please, in your brief, you say that the church should have sole authority to decide what is a religious use. How can that be? I mean, the statute does give the assessors a role in determining what is to be taxed.
And that's a very it's a very difficult and very easy question at the same time. I think once you make the determination that the dominant purpose of the house of religious worship is religious worship and instruction, the assessors should take a fairly hands-off view to approaching what constitutes religious worship. And I think there's a difference between use for religious worship and determining what constitutes religious worship.
Doesn't that turn the legal standard on its head?
I don't believe it does, Your Honor. In fact, I think that what the assessors did in this case and what the appellate tax board did in this case essentially turns the standard on its head. This court has found both under Clause 11th cases and also applying the First Amendment that what an organization determines is its own religious worship should be respected. I think when you get to the appropriation, I think that what the assessors are permitted to do is to make a determination as to the appropriation. That's not what the assessors did here. The assessors basically said religious worship and not religious worship. They didn't look at things that supported the religious worship, connected with, and I think that's important. You run the risk if you let the assessors determine what is religious worship. There are 351 cities and towns in the Commonwealth of Massachusetts. What the assessors in Attleboro deem to be religious worship may differ from what the assessors in the city of Worcester determine to be religious worship.
Given your articulation of the standard and the fact that you think that it's the church that should decide, can you give me an example of something that they would say is not something that would be exempt?
Yes, and I think that that's fairly clear from as far, again, I'm going as far back as 1840 to the Lowell decision, where there is a rental to a for-profit company where the company is doing something, in this case they were running stores, but it could be a manufacturing facility, a printing press. It's a for-profit company, has nothing to do with the mission of the church. The only nexus is that the funds are used to support the church. In those cases, the court has drawn a bright line and said that is outside the exemption.
Church would make that determination and turn over the funds?
I think the assessors could make that determination. If there's a for-profit store that's going on a regular basis on the La Salette campus, I think that's fair for an assessor to make the determination to tax that.
Okay, I'm a little bit confused about your dominant use and the view that the church gets to decide. Do we not evaluate with regard to each of these, with regard to the shelter, with regard to the conservation land, whether its dominant use is religious purpose or instruction, or supporting religious worship or instruction, or are you saying we should only do it for the entire entity?
I think you need to look first at the entire entity. And for example, with respect to the conservation land, I think if the church says its dominant use is for religious worship, that if there is any evidence suggesting that there is that use, if it's connected to the use of the church for religious worship, and in this case, there was such evidence. There was evidence that both the La Salette Fathers and retreat participants used that entire sanctuary land to support their retreat, to support meditation, to support individual worship. Where there is that evidence, I think the court cannot, neither the court nor the assessors should go further and say, well, is that really religious worship in the classic sense of religious worship? Because you would be excluding a whole group of religious entities, Native Americans, others who worship outside, and it's clear that this entire campus is used and structured for religious purposes.
So your dominant, I mean, doesn't that essentially render meaningless your dominant use test? Because the church will, of course, declare that its dominant use is religion. Nobody will dispute that. And then once you say that the church's dominant use as a church is religious, then the church gets to decide what the scope is of all the properties within its dominant use. So basically, we delegate, once we basically decide that the church's dominant use is religion, which of course it is, then we delegate to the church the decision as to whether the dominant use of all of its property is religious?
I think, Your Honor, the inquiry is the dominant use of the property, not the church. Obviously, most churches...
Dominant use of each piece of the property, or of I don't know what the property means here.
Of the entire property. Now, I will grant you that the language of Clause 11th suggests the possibility, the potential for apportionment. But when it comes to religious worship, if a religious organization says, for example, the sanctuary land is utilized for religious worship, and there is some evidence to that effect, I don't think the assessor should question that.
Okay, but the problem then is if we were to decide, well, there's a lot of conservation land, and the church area is small compared to the conservation land, and so the dominant use of the entire property is primarily conservation and not religious, and therefore, by your analysis, the church itself would not be within Clause 11, and that seems strange to
I
me.
think that's that's a somewhat backwards analysis, because I think what you need to look at, first of all, I'm not quite sure how you're defining the church is fairly small in this case. There is a connection, there is a church there.
Church
and
and the
it's
Welcome
not-
Center. But
And it's not conservation land per se. I think it's sanctuary land. It is conserved. I think there's a recognition that is historic and, in the Catholic Church at least, more recent, that preserving God's natural resources is an important theological tenet. But I think if we go back to the origins of this country, before we had our little white churches on the green, there were Native Americans in a polytheistic society that celebrated the divine through nature. And I think that scope, and when you look at the La Salette Shrine property, when you look at the Garden of the Apparition, when you look at the Rosary Pond, when you look at the outdoor Stations of the Cross, when you look at the outdoor chapel, so much is outside that you can truly view the sanctuary land as integrated. And I think it would be different, and a different case and a more difficult case, if a religious organization owned a piece of conservation land in, say, New Hampshire or even in Western Massachusetts, had its main church in the Boston area, but was totally unconnected with that conservation land. That would be a different inquiry. Here you do have an integrated use and an integrated campus, I believe.
all right, thank you.
Thank you very much.
Good morning.
Good morning.
Mr. Siddell.
May it please the court, Michael Siddell and James Hannafin on behalf of the Board of Assessors of the City of Attleboro. There are three reasons why this court should affirm the decision of the Appellate Tax Board finding that La Salette failed to prove an entitlement to an abatement: the statute, the Appellate Tax Board decision, and the Dover case. First, the statute. In Chapter 59, Section 5, there's three relevant clauses: 3rd, 10th, and 11th. In Clause 3rd, it deals with charitable exemptions. That clause says all real estate of charitable organizations is exempt, provided it's used for their charitable purposes. Clause 11th talks about specifically houses of worship and parsonages. The appropriation is a section of that statute that basically says the house of worship and the parsonage are exempt unless they're appropriated for other purposes. Clause 10th is the section of the statute that says all personal property of religious organizations is exempt. So the legislature had three different ways to deal with this. In Clause 10, they could have said all real property of charitable or religious organizations is exempt. In Clause 10th, they could have said all real and personal property of religious organization is exempt. Or in Clause 11th, they could have deleted parsonages and houses of worship and said all real estate is exempt. They chose none of those options and specifically said houses of worship and parsonages. It's interesting to note that the statute originally just had houses of worship as exempt. So according to La Salette's view, houses of worship in that case would have meant all real estate.
So if you have some stuff stored in the shed, and if you had a big enough basement in the church, you'd keep it in the basement. Does that mean that anything in the shed isn't available for an exemption? So the stuff that's in the shed right now, if, let's say that the basement were big enough, you wouldn't need the shed.
Correct. So the first line of inquiry is it a house of worship? If the structure is not a house of worship, the analysis can end there.
It has to be a structure.
A house of worship includes the structure and the real estate around it, and that's what the Dover case said. The Dover case was a 70-acre campus, and the court said, well, the house of worship includes the house of worship and 8 acres around that.
That seems awfully artificial if there's things that you need for worship, and you have to keep it in a shed because the basement's not big enough.
Well, I guess I could envision the opposite. So if material had to be kept at a totally separate location, it doesn't make that, unrelated to this campus, it doesn't make that land exempt as well.
Well, that can't be right, because we do have these cases that say it can be exempt if it's associated with religious worship and instruction. So where does that come in?
So I think that's where a house of worship, in this case, there is a parking lot. And the assessors included as exempt, as did the Dover case, a portion of land that was necessary for the house of worship. I mean, it's...
So is it your position that if it's not part of the structure that everybody would recognize as a religious house, that it's not exempt? Is that where you're going?
No, the statute says house of worship and parsonage. So parsonage was added 100 years later. And so my argument is, if house of worship had a broad definition, why did they add parsonage 100 years later?
And where does the land part come in?
The land part just, I think it's...
Is that in the statute?
It's not in the statute. It's a
So,
part
but
of...
you're saying that the parking lot's okay.
Well,
So I'm just
the
wondering on what justification that comes.
The case law and the legislative history expanded the scope of the statute, obviously from house of worship
So
to
it's not
parsonage.
just the structure.
Right, the case law said you need the land around the structure,
So it could be hundreds of acres of land around this structure?
if that is necessary for that house of worship.
So necessary is what our case law says?
I think I do think it says if it's necessary and related to the house of worship. So to the
So, but
extent you had a large...
a structure on that land containing the tools necessary to maintain the structure that is the house of worship itself, that you clearly are recognizing as the house of worship, that wouldn't be necessary.
Well, I think where is the limit to that? So if there's a...
Well, I don't know. I don't know where the land comes in. So, I mean, the land comes in, you're saying, by our cases, so not by the statute. You say it's not supported by the
Well,
statute?
buildings do sit on land. I think there is land around buildings, and I think the Dover case is the perfect example where they said, okay, 8 acres of a 70-acre was reasonably necessary. And again, in this case, we're not, I mean, the church was exempt, the chapels were exempt. We're arguing about everything
The
else.
storage shed that keeps chalices, Bibles, investments, not exempt.
Again, that's not the facts of this case, but if there's a storage shed on the back of the chapel, I mean, I don't see why that wouldn't be exempt to the extent that it's used for the purpose, and that is the case here. Lots of the land was determined to be exempt, 60% of the land, but there was no justification whatsoever for these other portions of the property to be included as exempt.
So if you had a synagogue and you had a shed, the same distance the shed is here from the, quote, house of worship, end quote, and they kept all sorts of extra chairs in there for Yom Kippur, would the shed be exempt?
Again, I think what the statute says is the initial inquiry is it a house of worship? And then secondly, what is the land surrounding that that is necessary and incidental to the house of worship. So the parking lot, again, I'm not an assessor, but in my judgment, I think that would be reasonable and necessary and incidental to the house of worship. But, you know, battered women's shelters and bistros and other, I mean, if there was an auto repair shop that served the vehicles of the parsonage, I don't know that that would fit within the house of worship category or the parsonage category.
So let's imagine a church, doesn't take much of an imagination, which has prayer on Sunday morning, and then people retire to the parish hall for a luncheon, and then maybe have other community events and church events in the afternoon. Small enough church, parish hall is in the basement or an adjoining area of the church. Parish hall is within the Clause 11?
The parish hall is within the church. Again, I think this is why the legislature was wise in the way they crafted the statute to say house of worship and parsonage are exempt.
So the answer is no?
Well, to the extent it's in there,
Even
if
if
it's
so,
not.
so the view is that in terms of a church, the worship occurs only in the sanctuary.
I don't think the legislature wanted assessors to be making determination about what was worship and what wasn't.
But you are.
No, what they said was, if a portion of the house of worship or the parsonage is appropriated for another use that's unrelated. And then they said, hey, the exception to that is if you're a 501c3 corporation, we don't think that's an appropriation. So in your example, I don't think if there was worship in a church and they went downstairs to a cafeteria facility.
Well, I mean,
and
it's a parish hall. It's multi-use. Most every
Yep.
religious institution I know has one.
Well, I don't think that would deviate from what happened here, which was all of that was exempt.
So that area is exempt.
All of that was exempt.
Okay, and
in
what
this case.
and what distinguishes that parish hall from the Welcome Center in terms of being able to handle very large numbers of visitors, pilgrims, students?
I think it's also used as a corporate retreat center. I think it's also used as a polling station. I think it's also used
The
as,
parish hall, separate building. Parish hall has CCD classes. But it also has all sorts of community events, as the chief was indicating. And people rent it out for wedding receptions or receptions after mass. Are you saying that because there's some for-profit taking place, that it can't be exempt?
I'm saying it is not a house of worship. It's not a parsonage. And so what the assessors did in this case.
Even if the little kids go there for CCD?
Even if kids go there for CCD, it was apportioned, it wasn't totally exempt. And so, again, to go back, what did the appellate tax board find? They found that the assessment by the assessors was proper, that the board perceived no error in the methodology regarding the apportionment by the assessors, that Salette offered no persuasive or credible evidence to refute the methodology, and that much of the property was used for other than religious worship or instruction. And so those were the ATB findings, which concluded that they weren't entitled to an exemption on these other portions of the property. Finally, the Dover case. And again, Dover reconciled the differences between Clause 3rd and Clause 11th. To some extent, the facts are identical, and to the extent that the court found the portion of the taxpayer's property devoted towards religious worship, including 8 acres of land, and again, I think that was in the assessor's judgment, didn't concern the court because it was exempt, just as it was here. All of the house of worship and parsonage land was exempt. The question in Dover was was there any exemption available for the remaining portions of the property? To that, they turned to clause 3rd. In this case, clause 3rd was waived. So there is a right to make a claim for an exemption under clause 3rd. It was waived in this case. And so because La Salette cannot prove an entitlement to the exemption, they should not be entitled to an abatement. Thank you.
Okay, thank you.
Thank you.